Okay, so today's topic is called COVID-19 and the ethics of legal survival. So we obviously are all living in this really complicated, stressful time period. And what's evolved from this has been a lot of questions in the legal field, business, real estate, whatever you can think of. COVID has had some kind of impact. And so we're going to explore what some of those impacts have been on the legal and business side of things, but we're also going to come at it from a slightly unique perspective in that we're also exploring kind of the ethics of some of these decisions and questions. So not just the mechanics of how to answer what to do about a force majeure clause, but also whether one should be enforced at all. So like I said, work with the Institute for Business and Professional Ethics. The Institute is housed at DePaul University. We are going to have 3 speakers today, and these 3 speakers are each going to speak for about 15 minutes, and that will total about 45 minutes total. And then we will wrap up with a Q&A session. And we encourage you to use either the chat function, or there's a Q&A option as well where you can submit something anonymously, where you can put your questions throughout today's presentation. So if a question comes to you in the middle of Candice's talk and we don't get to it for another 20 minutes, you won't forget what you had to say. So we welcome you to do that throughout, and then we will make sure to get to it at the end of the session. I want to remind you that this is being recorded today, so if that might impact what you want to say on chat, or if you decide to submit something anonymously, that's up to you. Of course, we are also offering CLE and CPE accreditation for today's event. I will be sending out attendance certificates and confirmation of that credit to you all at the end of today's event, and along with the slides from today's event and contact information for our speakers. So the Institute for Business and Professional Ethics is at DePaul. It's housed in the Driehaus College of Business and the College of Liberal Arts and Social Sciences. We've been around since the 80s. And our main focus is to really provide an opportunity for people to do research, to teach, to really be considering some of these big questions around kind of societal ethics in business and professional fields. And we have 4 major constituents: students, faculty, the business community, and the Chicago community. I imagine there's many of you that fall into one or more of those categories today, and we're happy that we can provide some programming for you. We also have other programs that we provide throughout the year. Most things are being done virtually these days, but for faculty and students, we offer fellowships and scholarships. We also write and produce case studies, ethics case studies that are targeted towards newer employees, or also the undergraduate audience. They're the DePaul mini cases. You can find those at depaulminicases.com if you'd like to explore a little bit more about what you can maybe bring to your own workplace or your own classroom. You can find more about DePaul University and the Institute at go.depaul.edu/ethics. You'll see that on the slide, and you can go ahead and explore a little bit more about the Institute. You can also find us on LinkedIn, Twitter, and Facebook. So I'm really pleased to have 3 speakers here today. We have, I can't see my notes when I'm sharing things like that. So let me pull this up. We have 3 speakers today. The first is Denis Demblowski. He is a legal analyst with Bloomberg Law. He focuses on commercial transactions and corporate law. He has practiced in-house for 32 years at Alcoa Inc., which is a global manufacturing and industrial company in such areas as compliance, corporate executive compensation, finance, corporate governance, general commercial, international, M&A, and security. So he's a man of all talents in that space. Denis is a graduate of the University of Pittsburgh School of Law. Our second speaker will be Candice Kline. Candice is a partner at Saul, Ewing, Arnstein, and Lehr, and she focuses on bankruptcy and restructuring litigation. She is also on the advisory board for our institute, and we're happy to have her, and she serves in leadership positions for various bar and trade associations. Candice has an MBA from the University of Chicago, in addition to her law degree from the University of Toledo College of Law, and she began her legal career after many years in the global commercial banking business, including some startups. The combination of this kind of practical business and legal experience provides sort of an uncommon value and expertise that I think we're going to be very lucky to check into. She also lends a hand with her husband's glass blowing and furniture making business. So this woman is very busy and multi-talented. Our third is Professor Daryl Koehn. Daryl is the Wicklander Chair of Business Ethics and the Managing Director of the Institute for Business and Professional Ethics. She is published widely in the fields of ethics, political theory, corporate governance. Her monographs include, just a few of them, are The Ground of Professional Ethics, The Nature of Evil, Rethinking Feminist Ethics, and Living with the Dragon, Thinking and Acting Ethically in a World of Unintended Consequences. She has also edited volumes including Corporate Governance, Ethics Across the Board, and Ethics. In addition, she's published scores of articles in the Harvard Business Review, Business Ethics Quarterly, and the Journal of Business Ethics. She regularly consults with major corporations and has served on a major corporations compliance committee and has been profiled in Time and Life. She received her PhD in philosophy from the University of Chicago, an MBA in finance from Northwestern, and a master's degree in politics, philosophy, and economics from Oxford on a Rhodes Scholarship. So you guys are lucky to have an amazing slew of talented and intelligent people here today to kind of discuss this topic with us. So let me move it along, and I will allow Denis to get us started. Denis, you want to unmute yourself?
Okay, can you hear me now?
Yes.
Okay, great. Can you pull up the first slide? Good afternoon, everyone. It's really a pleasure to be a part of this panel and to be here with you this afternoon. You know, when I first heard the title of the presentation, I just said, wow, that's a marvelous title. COVID-19 and the Ethics of Legal Survival. There's a lot in there. And you will see in our presentation, there's kind of a natural crescendo to what we'll be talking about today. We're going to start off really with the basics, a little bit of maybe a dry subject, a legal subject on what force majeure and some other contract excuses are. And then we'll get into more interesting material that Candice will cover primarily on the employment side. And then finally, you know, into the real meat of the ethics of the situation and what we're all facing. Force majeure and the pandemic. Force majeure means literally a superior force, a supervening event. It's a creature of contract. It means whatever the contract says it means. It's an agreed set of occurrences or events which, if one occurs and affects the ability of a party to perform, the parties agree that the party that's affected is entitled to relief. It's either excused performance or the performance is delayed. A force majeure event is whatever the contract says it is. Now, for many practitioners, especially prior to this year, the notion of force majeure was an afterthought, stuck in what we call the boilerplate at the end of a written agreement and handed down from contract to contract without significant negotiation, discussion, or change. What that means is that the force majeure clause in a long-term office supply contract often looks exactly the same as the force majeure clause in a critical raw material supply contract. Under the force majeure heading at the back of the document in the boilerplate, the parties qualify the terms that they've expressly agreed to in the front of the document. Let's think about that a second. The parties have just engaged in extensive negotiations, discussion, drafting about the quantity, quality of the product that's involved, what its pricing and delivery terms are, warranties, remedies, etc. Then buried at the back of the contract, they say, forget everything that we just agreed to. If certain things happen, the deal's off, or it's suspended or delayed. the affected party is excused. Force majeure is a risk-shifting provision. The party that is affected by it, the risk of that, the consequences of that is shifted to the other party, in effect. The practical effect is that the commercial financial risk of the event is shifted from the affected party to the non-affected party, who's left holding the bag. That party needs to find another solution or another source of supply or of outlet of its product. Can we go to the next slide, please? Before this year, what does a typical force majeure clause look like? I won't read the whole thing to you, but it's basically two parts. They say, if certain things happen, and then they give some events like acts of God, tornadoes, hurricanes, natural events, explosions, man-made events too, labor disputes, government orders, change in law. If these things happen, then the party's excused or performance delayed. And then they throw in a catch-all in at the end that say, okay, if these listed or enumerated events occur, the deal's off. But if anything else occurs that's beyond the control of the party, that is also a force majeure event. Next slide, please. There's an alternate way of saying the same thing, and that's just to say the last words. If anything happens that's beyond the reasonable control of a party, that's a force majeure event. That excuses that party from performing. Now, it seems very simple, but it's open to interpretation and, of course, dispute. Next slide. Force majeure results in an excuse. There's kind of four elements of it. The event is not reasonably foreseeable. It's beyond the reasonable control of the parties. It affects, in a material fashion, the ability to perform the contractual obligations, and all reasonable steps have been taken, there's no reasonable steps that can be taken to avoid or mitigate the event. Excuse me. Okay, the next slide, please. What are some of the typical enumerated events, the laundry list of horribles that could happen? There's the rubric is acts of God, which usually means natural causes. You know, the weather, any other kind of things that happen naturally. And then you have a lot of man-made events, wars, blockades, riots, strikes, labor restrictions, logistical delays. The list can go on, and some contracts go on forever on what can be a force majeure event. But you'll notice in what we just went through, there's no mention of a pandemic, of a widespread disease, epidemic. There's nothing about a government lockdown. These are what we actually experienced. And the questions beginning in March of 2020 started pouring in to every law firm, to every legal department in probably the world about, well, is this a force majeure event? Is the pandemic a force majeure event? Is the lockdown a force majeure event? And the answer is, well, I don't know, it depends. What does your contract say? And of course, the contract never says exactly what happens. And that's the risk of when you have a laundry list, you take the risk that you're going to miss something, and that somebody somewhere is going to say, no, you only meant the things that you expressly listed, because it's a contract term, and contracts are subject to interpretation, and the interpretation is under state law, which varies. You know, we have 51 jurisdictions, and they kind of take a little different a twist on how they interpret these clauses. Most will interpret them very strictly. Why? Because force majeure is an exception to the other terms of the contract. And again, as I mentioned, some take the position that only the listed events are the ones that will constitute force majeure. Before 2020, no one realistically thought about the possibility of events such as pandemics, lockdowns that we actually experienced ever occurring. As an example, before 9/11, no one ever listed terrorist acts as a force majeure event in their commercial contracts. Now that's a staple. It's always mentioned. So what's going to happen post 2020? Next slide, please. Post-pandemic, we're going to see some of those words in bold. You're going to see them all over the place because people say, well, wait a minute, it can happen. So, Murphy's Law, we better be prepared for it happening. So they will list epidemics, pandemics, disease, government shutdowns, curfews, stay-at-home directives as types of events that will excuse a party. They may take the opposite approach. It depends. This is a negotiation. Some parties may say, wait a minute, I don't want to take that risk that those types of events will excuse you. They may excuse me, but I don't want them to excuse you. So, sometimes they will say these types of events are expressly excluded from the coverage of an excuse for a force majeure clause. It remains to be seen how this really will start playing out as we get into the post-pandemic commercial practice of whether these types of events are expressly mentioned or expressly excluded. Next slide, please. Invoking, we got a lot of questions. I got a lot of questions asked of me of how do we advise our subscribers on what they need to do to invoke a force majeure clause. Well, first of all, you have to review the terms of your contract, as I've already mentioned too many times. Second, you have to notify the other party. Hey, something's happened, and this is what it is. And what you tell them, try to mirror as closely as possible the exact words that are used in the contract. If hurricane is listed and a hurricane happened, you say a hurricane occurred, on such and such a date, and it caused this type of damage. And because of that type of damage, which was outside our control, because of that type of damage, I can't perform the contract. But I'm notifying you, and I will keep you informed, and we will try to get back into production as quickly as possible. But until then, I'm excused. And as I mentioned, the vast thing, be prepared for pushback. Not everyone's going to agree. Your counterparty is not always going to agree that especially if it's not an exact specifically listed event, that it's a force majeure, that it's a supervening cause. They will also argue that it didn't cause you to not perform. There was some other reason why you weren't performing. Maybe it's because of all the costs that you've incurred, but it wasn't because of the storm, or it wasn't because of the pandemic. And so there will be disputes, and that's when you go into courts and they leave it up to the court to decide. What if there is no force majeure clause? Not every contract needs to have a force majeure clause. Does it mean that the party that's unable to perform due to war or some devastating weather event has no choice but to admit a breach and pay damage? Well, no. You can guess the answer is no. There are provisions, other provisions that may be grounds for excuse. The UCC, the Uniform Commercial Code, which generally governs contracts, especially for the sale of goods in the United States, in each of the states, gives, in this section that I've referenced there, 2615, it applies, it says that it's an excuse for the seller only. So a buyer cannot take advantage of this provision. And what it says is the seller is not liable for failure to deliver or for delay in delivery if the seller's performance has been made impracticable by the occurrence of a contingency, read force majeure event, some sort of supervening cause, the non-occurrence of which was a basic assumption on which the contract was made. No one thought that there would be a pandemic. Or by compliance in good faith with any applicable government regulation or order. So here it would cover the lockdown. If that was the reason, if that was the cause for the party's non-performance. So there is, some available provision that a party can, that's affected by one of these events, even if you don't have a contractual force majeure provision, you may have some other means of excuse in your contract. Next slide, please. There's also, just to mention, if you're dealing with an international setting between a buyer and seller in different countries that are parties to the UN Convention on Contracts for the International Sale of Goods, that law will apply, not the Uniform Commercial Code. But it has a similar provision. It deals not with contingencies or force majeure, but it calls them impediments. If an impediment occurs that was beyond a party's control, that impediment was not foreseeable at the time of contract formation, could not be avoided, and it caused the non-performance, then the party's excused. So it's a very similar result in the international setting as well as just a purely domestic setting. Next slide, please. Going back to the domestic setting, just two minor comments. Sellers still have some obligations, even if they're excused. They have to allocate whatever production they do have and whatever deliveries they can make in a fair and reasonable fashion among all their customers. And of course, they have to notify them. The big question is, what's commercial impracticability? It's one of those amorphous terms that can just about mean whatever you want it to mean, but it's very clear that an increase in the cost of a party's performance is not enough. So there has to be something else that occurred that caused maybe the costs to go up disproportionately. As this bullet point says, if it was a result of certain, unforeseen events, which caused a marked increase in cost or prevents the seller from performing, then that is within the contemplation of this Uniform Commercial Code provision. Next slide, please. What if the UCC is not available, or the UN Convention? What if we're dealing not with the sale of goods? For instance, it's a service agreement. So we have a contractor and a client, and the contractors cannot perform for some reason that would be in the nature of one of these supervening events. What if there's no force majeure clause? We still have some backup common law, which means judge-made law, which can apply. The two are an impossibility of performance, which is an objective test. The contract can't be performed by any means. And then we also have frustration of purpose, which is more of a subjective test. The purpose of the party's principal purpose is frustrated. So let's go on to the next slide, please. Impossibility has kind of been diluted over the last several decades, and is now very similar to the impracticability standard of the UCC. Where it generally comes down to what's stated there on the slide. And just to give that illustration, Party A contracts to repair B's grain elevator. While A is engaged in making repairs, a fire destroys the elevator without A's fault, and A does not finish the repairs. Okay? A's duty to repair is discharged and is not liable for breach of contract. A wants to perform, but it's impossible now. The fire has destroyed the very nature of what the parties have agreed to. If you just take a little twist on that, what if B, the owner of the grain elevator, wanted to get out of it, wanted to get out of the contract? Is it impossible for him to perform? No, it's not. All he has to do is pay money. But this is where the kind of the flip side, the coin, comes in, and that's the frustration of purpose. Next slide, please. And B, in that situation, would have a frustration of purpose defense, and it would be discharged from the obligation to pay, because The reason why he hired A to begin with to paint his elevator was because the elevator's there. Now that it's not there, there's no reason for it. There's another illustration that's given here for frustration of purpose. And that's where party A leases some installations to advertise neon signs. The government prohibits the lighting of those signs subsequently. B, the customer refuses to make further payments. B's duty to pay rent is discharged because the very purpose for which he entered into that contract was to have those signs lit up available for him. Now he cannot have that. Next slide, please. Some closing thoughts. Freedom of contract prevails. Those lawyers among us who remember that clearly from law school. The parties can generally agree to what they want to agree to. So if they want to agree that certain things will excuse their performance, they're certainly entitled to do that. When you draft a force majeure clause, you can go kind of one or two ways. You can give the big laundry list, or you can go with a simple any cause beyond the control of a party. The risk of going with a laundry list is you fail to list the exact thing that actually occurs. And some court somewhere says, well, you didn't list that one, so therefore it wasn't within the contemplation of the parties. It's not a force majeure event. The risk of the second one is you're going to have to, if it's disputed, you're going to have to go to court. And that's a very expensive process. There are performance excuses that were developed at common law, as we mentioned. They're more equitable in nature. In other words, they're based on the principle of fairness. Is it fair to require a party to continue to perform when the purpose for which you entered into that contract no longer is viable? And then the final comment and observation is that when a party is excused from performing for whatever reason, the other party bears or shares the consequences that flow from that event. So as I mentioned before, they're kind of left holding the bag. If I had a contract to purchase widgets, but those widgets can't be delivered for some reason of force majeure by the seller, I have to go out and find widgets somewhere else, or I have to go back and tell my customers I can't supply you widgets because my suppliers failed. So it really does share the responsibility. It brings both parties together to try to resolve the issue in some amicable fashion. With that, I'll turn it over to Candice.
Great. Thank you, Denis, for giving us a great kind of baseline overview of what the main legal issue is around this topic, which is force majeure. So I'll hand it over to Candice.
Great. Thank you, Denis and Summer. And I'm going to extend from Denis's presentation and talk a little bit about COVID and some live litigation scenarios, notably in the employment space. Obviously, the stats for COVID are not good. They're growing. From an economic standpoint, obviously there's varying degrees of recovery, whether by industry or by location. That plays into, for example, the discussion about force majeure and what the legal remedies are, as well as whether part or whole performance is possible. Some areas more open than others, right? So if you're a business in Florida or Texas, you might have different options, issues, and headwinds than if you're a business in San Francisco or in Chicago. But COVID remains a very real threat, as well as an issue for our business environment. And the legal issues are many. We talked about force majeure and the principles around impossibility or impracticability. We also have contract actions based on simply breach. Eviction is a flavor of a contract action, and obviously you hear a lot about eviction in the press right now. Constructive termination, business interruption and exclusions, a significant amount of effort around insurance coverage, trying to get insurers to pay for the harm that has been caused by COVID and government orders and advisories related to COVID. Negligence, reckless, conscious disregard, other kinds of intentional misconduct. COVID can also prompt fraud. I'll use an example. You want to fluff up your financials in order to qualify for additional financing. Obviously, within the PPP program, there has been evidence of fraud. So you get a bit of a flavor of that related to the COVID event, and then also constitutionality. And you see that bubbling up, whether it's, say, for example, religious services in the COVID environment and the treatment of secular and non-secular that was just up before the US Supreme Court. But also there's a case in Michigan right now talking about a takings, which I think is actually interesting. From an impact of these government orders. If you have the great misfortune of being labeled non-essential, then you essentially have lost a significant amount of ability to pursue a livelihood and to protect your property and property interests. All of this requires, and I give you just a couple examples of a very fast-paced dynamic environment where you're constantly looking at and understanding and adjusting your legal liabilities and your contract posture. A lot of companies have never read the force majeure clause before COVID. It's just boilerplate in the back, something that the lawyers used on their form. Folks didn't think about it. Insurers, for the most part, had thought about pandemic risk with regard to their policies because they've been here before. This is not our first modern pandemic, and you don't have to look back to 1918 to see that risk. So insurers generally are in a better position than, say, folks who are relying just on some contract boilerplate. You're looking also at places to legitimately seek aid for your business and your enterprise and question whether or not you have a duty to do so. If it's available and you qualify, are you obligated, for example, the Payroll Protection Program, PPP, are you obligated to go out and try to protect the payroll of your employees? If you have local grant programs, right, City of Chicago, Cook County, just for a couple examples, what is your responsibility to understand and try to leverage those programs before you even try to, for example, not pay rent? And this also comes up in litigation scenarios. Did you do everything possible to get money into your business or your enterprise or say your nonprofit? Understanding the government orders and taking appropriate precautionary measures. Let me translate that into a duty of care. So if you're running an enterprise, you should stay ahead of all of these guidances, which are ever changing. They're difficult to navigate for a lot of organizations. We'll talk about a couple examples here. So that means you're always doing the best you can. And again, from a standard of care perspective, that's just fine. From a business management standpoint, that's just fine. But you actually need to keep working on it and adjusting to this dynamic environment. So let's look a little bit on case trends. We're talking about force majeure that puts you in the land of contract. And indeed, most cases that have been filed under COVID, just assume these trends through May exist. They're just more. You have mostly contract-based actions, followed by insurance and then employment actions. And this is based on federal district courts. A lot of these cases get filed in state courts. We'll talk a little bit about this. In bankruptcy and other say, efforts that have some sort of flavor of, well, why did you become insolvent? Or, what were the issues faced by the company? You're seeing in what's called the first day affidavit in the bankruptcy Chapter 11 context, a lot of discussion about COVID. And in many of those cases, I mean, COVID was not the reason the company filed bankruptcy. JCPenney was headed towards bankruptcy well before COVID. But you are seeing this as an excuse or as an explanation for underperformance financially and the need to pursue some of these extraordinary remedies, such as a bankruptcy Chapter 11. One factor here that's interesting is that there has been generally a court slowdown. Some courts have been better in terms of keeping up their docket and moving through proceedings. Trials obviously impaired everywhere. But I have seen a significant variance, and even here in Illinois, this morning as an example, I had a status conference in McLean County, not a problem, it's on Zoom. I have another case that's just, in a holding pattern with no information whatsoever in Cook County. And so when that happens, it means that, you're maybe not going to see all of the filings, and you're not going to see all the progress, and you're not going to really see all the case law develop as quickly as maybe we would like. So we'd know, for example, how some of these actions will work themselves out, because courts themselves have been adapting to the COVID environment, and that has had a bit of an impact as to how we, how we get through the legal process. So I'm going to talk about employment and some general case trends. And obviously the center of action tends to be in food, hospitality, anything in the ag supply chain, entertainment space, restaurants. So again, if you got tagged with non-essential and you're considered to be in the crosshairs of COVID infection, you got an issue. And this has obviously precipitated several bankruptcies. I'm going to talk about one bankruptcy here in the Northern District of Illinois, where the landlord, he's not getting paid. The tenant files bankruptcy, it's a restaurant. Landlord files a motion to compel the debtor to pay post-petition rent, which is required under the bankruptcy code, or otherwise to modify the automatic stay so that they can pursue the eviction remedies. The debtor tried to argue force majeure. It's excused from paying rent, absolutely, because of the COVID lockdown. However, there's a caveat. So the situation in Chicago and many other jurisdictions was not an absolute bar to performance. Rather, those advisories and orders have, they tried to find a compromise and permit curbside delivery, takeout. Obviously, that got expanded over time, for outdoor dining, as an example. So there was some basis by which restaurants could continue their performance and their business. So the bankruptcy court tried to develop what I would call a proportionate response, which is to just reduce the liability on the rent to conform with the amount of business that the restaurant could be reasonably expected to conduct under the applicable COVID orders. And so they came up with this formulation. Yeah, I'm sure it was a tremendous disappointment to the debtor because they didn't get a free pass. The court still required them to pay some rent. And in fact, no payment occurred. The stay was lifted. It's over. So this was an example where, there might be a strategic desire by debtors, or the party that wants to excuse performance to use force majeure, offensively. To try to say, hey, I just have no liability here, or, for example, there was no desire to pay rent. What that also does is it transfers the risk and cost of COVID from the restaurant or say, the principal affected party to other third parties, such as the landlord. Well, then the landlord's impacted. So then who's impacted after that? Well, then the banks, or maybe investors. And then who's impacted after that? Well, ultimately taxpayers. So, this is actually something that's a little bit interesting as to how parties negotiate or don't negotiate or try to transfer or share risk between each other. I'll go to the next case, and this is a meat processing case, pork processing. Tyson was in the news. There are others, Smithfield, for example. I'm sure most people following the news have heard about these meat packing cases. The situation, the employees are packed very, very close together. There was really no practical effort early in the pandemic to try to keep employees safe, but because they're in the food chain, they are considered essential. The companies are excluded from all of these, shutdown orders, and they're trying to do business as usual. That became very difficult because COVID really enjoyed that environment for infection and transmission. And across all these facilities, thousands of employees were infected with COVID and many died. And in fact, Fernandez died, and it is the administrator of his estate who is bringing this action. The case is interesting because it prompted a couple things. One is that obviously Tyson and other folks in the meatpacking space, and I'd say greater ag, stepped it up in terms of trying to promote workplace safety. I provide a screenshot of Tyson's report on their efforts, which you can easily find on their website. Obviously, this was not at the very beginning of COVID, but it is there now. So everyone seems to have said, yes, we will do, suitable remediation, lots of attention here. But furthermore, what's interesting about these lawsuits is that it's claims against the company as well as the executives and the supervisors. And they're pointing to several points. One is intentional misconduct, right? So you're looking at fraudulent conduct, willful and wanton disregard, right? This isn't just negligence. This is in the realm of gross negligence. This gets you into punitive damages. They can be very, very costly. Some of the facts that were reported were pretty, incredible. So in both of these Iowa cases, there's facts that said that the supervisors had established betting pool, so a cash pool, and whoever's closest to guessing the number of employees who test positive. So there's a callousness that's also evident in how the supervisors and the people operating the plant were confronting COVID and employee concerns at the time. That's probably a bad sign, hence the lawsuits. So when you look at these cases, there's two things about them. So one is that there's claims that also can produce personal liability. They produce adverse employment actions. In this case, the supervisors were let go. They did do mitigation at the plant, but it also means with this kind of legal attention that there was a step-up effort in terms of, the COVID precautionary proceedings. So again, they're essential. They must continue in operation. They're in the food supply chain, but more can be done, and more has been done. Another example, this was filed earlier this week. As I said, the lawsuits just keep coming, fast and furious. And this is with Estes. So, now you're in the logistics space, you're still essential. And we have a coronavirus outbreak in a facility in Illinois. A dock worker becomes aware of this, becomes fearful of the situation. The supervisor basically says, you're not going to catch a break here. You have to, essentially maintain, your regular work hours and performance. So the employee did come and he worked a partial day. So he worked an 8-hour day, not a 10-hour day. And he's still fearful of this infection. He comes in the next day and he's fired. So once again, you see a complaint, and as you can see by the caption, it's in federal court because the damages, are over $75,000. And they're arguing federal question. We'll see how SD's responds to all of this. But, the point here is that you're disregarding these legitimate fears. But are legitimate fears enough? And can you establish facts that say, hey, the company itself didn't do enough to protect employees or to mitigate risks? You can't obviously eliminate risks, but you can certainly mitigate risks. And so, what is the appropriate conduct here? And that area is somewhat gray. But again, notice that Estes, which is a large company, is facing this lawsuit because of conduct pretty low in the organization at a supervisory level at one site with, one loading dock. So again, when you think about company response and the tenor and the communication and how they operate in the COVID environment, is there enough getting pushed down through the organization where these decisions really matter? Another workplace safety situation is Amazon. So here we had, this is in New York, the employees actually walked off the job, just a lot of attention around the work conditions. In the case of one employee, they have claims where quarantine pay had not been paid in full to the employee. Again, that was mandated by state law. So you're looking within these complaints for, okay, well, what are they going for? They're going for the protection, health and safety of employees. They're protecting wages. This is what typically happens in an employment action, but you get this extra bit. And here it's public nuisance and a declaratory judgment about unsafe working conditions. So again, you're always looking at what's the appropriate response. And in some cases, you have to make decisions. If you're essential, I'll use an example, if you're deemed essential and you're operating in the COVID environment, then, probably makes sense to do as much as possible to have mitigation. If you're non-essential, maybe you do less, maybe you're just closed. And that also has implications. If teleworking is available to employees here with Estes and Amazon, they're not. With Tyson Food, they're not. But think about risk and transfer. A university or a law firm, such as my law firm, has a lot more tools at its disposal to mitigate risk than, say, a transportation company, than, say, UPS. And is that fair? But generally, these lawsuits are suggesting that fear alone is not enough. So employees have to go a little bit farther as to, what they want to, argue in these complaints. You can't just be fearful of COVID. You have to actually find misconduct, which is either negligence or it's intentional. I drew up a few hypotheticals just to think about them. I'll do the first one, which is based on a real life scenario. So you have a CEO, they've read all the orders, they've prepared, they bought masks and hand sanitizer for the office, took away the coffee machine so people don't congregate in, the break room. And the CEO is showing up every day and hasn't caught COVID, feels like it's very safe. Social distancing is certainly viable in the office. So the CEO, when reopening became available, decided to require all employees to work from the office. And the view was, because there is a view in management, that remote working is not productive. You're not promoting culture. It's difficult to risk manage in that environment. People are slackers, especially, folks who, midday, what do you mean? You have to teach your kids Zoom or, walk the dog. Unacceptable, so you got to come to the office. And in that context, multiple employees who know that teleworking is available and know that other competitors in this industry are teleworking, they complain to the local Department of Health. And the local Department of Health shows up. No violations are found because all these measures are being taken. But what should the CEO do in this scenario? You know, so it's a communication issue, it's a philosophical issue, maybe it's a little political. But employees don't have, in many cases, I'll put it that way, don't have an absolute right to teleworking in the employment context. There's certainly concepts around reasonable accommodation. But if the contract for employment, which here is at will, suggests that folks should appear in person and work from the office, that's important. Furthermore, the CEO could point to instances where work productivity and work output were perhaps a little, less viable. But I'll say here that what the CEO did was actually try to find out who the whistleblowers were, and indicated that they were very unhappy that someone was, and it had to be internal because they were not allowing any guests at the business, someone internally was complaining to the Department of Health without ever even, for example, complaining to the CEO directly. So, I would be, a little careful if you're in this environment from both the management perspective as well as the employee perspective as to how you navigate that conversation around COVID risk management and comfort. I include a couple resources. I think Summer will have resources for attendees. These are all live links if you want to learn more or follow any of the COVID directions. So with that, Summer, I'll turn it over to you.
Awesome. Thank you so much, Candice, for kind of expanding this question of legal liability and kind of business strategy even further. We're going to now move on to Daryl, who is going to talk a little bit more about the ethics of some of these decisions. Candice, would you mind stopping to share your screen? There we go. All right, Daryl.
Okay, we're good to go? Okay. So thank you, Candice, and thank you, Dennis. You've set me up very nicely, but I am going to shift gears here a little bit because I'm not a lawyer. My training is as an ethicist and a business and professional ethicist. And I've been asked to think about what are the ethical principles that might be relevant to thinking through the ethically right and wrong responses as companies struggle to maintain their legal survival. And I'll say at the onset that my thinking here is really preliminary. I think this is a difficult area, and I've not yet heard any presentations at a business or professional ethics conference on the ethics of some of these matters, and certainly not, I haven't heard any kind of presentation that's systematic. So I've come up with 6 principles. I don't claim that they're the only 6 principles, but they're the ones that occurred to me as potentially relevant to thinking through company responses. So here goes. I'll go through the 6 principles and give you illustrations as we go along. And I'll say a little bit about what I take to be the foundation of the principle. Obviously, if this were a conference or a class, I'd say a lot more about the foundations, but I'm just going to treat the foundations in a rather schematic way. So the first thing I would say is that basically, the first principle is when you think about business is to think about what business is for, what makes for a legitimate business in the first place, an ethically legitimate one. And I would say it's really the goal or the end of business that gives business its social legitimacy. And it's also this legitimate goal that underpins the history of the corporation. And what is that goal that makes a company socially legitimate? It's, as my friend, colleague, Ken Goodpaster says, it's to provide genuinely good goods and services that really serve. So, of course, we could talk a little bit about what is a good, genuinely good, and what services really serve, but you do have some sort of minimal requirement to be providing good goods and services that really serve. I would say that this principle is material in the sense that it kind of goes to the what of business. So if you want to think of an analogy between business ethics and professional ethics, some of you as lawyers are more, probably more familiar with legal ethics. Legal ethics are controlled in part by the end of the legal profession, which is legal justice. There are certain behavioral duties that derive from what that goal or end is. And that's why I'm saying it's material. It's the stuff, the stuff of the practice that is relevant here. Now, what we're seeing is many businesses are retooling and other ones are coming onto the scene. And I think when we look at what businesses are doing, we need to remember first and foremost always that businesses do not exist just to survive or even to make money for shareholders. As I always say to my students, you can make a lot of money doing child pornography. It's an extremely lucrative business, but it doesn't mean that child pornography is a socially legitimate or a sanctioned business. So at no point would a business be ethically justified in cutting corners in any way that results in marketing of goods that are not real goods. So I'll give you an example of some things that businesses have done that I think are perfectly acceptable in the sense that they comply with principle one, that the company is providing genuinely good goods and services. So for example, Dyson, the vacuum cleaner, has retooled to offer ventilators. Vacuums suck things in, but they've developed technology to push air out that they are now using, as my understanding, in British hospitals to provide ventilators for people who are sick with COVID. LVMH, the luxury goods company, has retooled its perfume business that relied upon alcohol to provide hand sanitizer. GM in China is working with some of its Chinese partners to take some of the materials used for car seats and so forth to retool that material into surgical masks that they're making available. So we do have plenty of companies that I think are not acting in suspect ways because they're providing genuinely good goods that support, for example, health, public health. But you do have businesses that are shifting into, or businesses that have come on the scene to provide fake masks, vaccines, COVID-19 cures. And to me, it's irrelevant whether or not the consumers are voluntarily buying these products or whether or not the firms are avoiding price gouging. The basic problem here is that these firms are in violation of principle one, the material principle to provide genuinely good goods and services. Fake masks are not a good good. So principle one is certainly relevant here. Principle two, and this goes to matters that Candice, I think, was just talking about in connection with the Watts case and the Tyson case, is to think about the need for businesses to avoid coercion of various stakeholders. So this principle, I would say, is a formal principle. It doesn't derive from the specifics of the good that the company provides. It derives from the fact that businesses are operating in a market context. So if you think about the analogy with professions again, there are certain principles and duties that lawyers and doctors have that come from their goals of health and legal justice, but there are other constraints on their behavior that derive just from the fact that you have to act in a trustworthy way, and that trustworthiness itself imposes on any kind of exchange certain kinds of constraints. So similarly, businesses not only have particular material goods that they pursue, they also have formal constraints that derive from the fact that they're operating in a market context. So introducing coercion into a market context vitiates the market context because it's no longer a sphere of voluntary exchange if the exchanges have ceased to be voluntary. So you can see that there's been some concern about this in the case of universities, which are corporations, where the universities very quickly, under some guidance from AAC and from the NCAA, moved to say, well, we would like our student athletes to show up, but we will not coerce them into playing. They have the option of opting out, and they still get to keep their scholarship, or at least keep partial scholarships, even if they choose not to play, say, football or basketball. So here I would say you have a case where the institution is trying to avoid coercion. They're trying to act in accordance with principle two. Another case that's starting to be featured a lot on the LinkedIn feeds for compliance and integrity have to do with whether or not businesses will be able to legitimately require employees to be vaccinated before returning to work. So I'll just show you here a screenshot of the LinkedIn survey. This was posted by Muel Captain, who's a partner of KPMG. He was asking, what do people on the LinkedIn feed think about the requirement by employees that employees be vaccinated? 40% of people thought it wouldn't be ethical under any circumstances. I was here in the 52% who thought that I think you could be required in specific circumstances. So why can you require it? Well, basically, companies do have to take some measures to protect the health and safety of their employees and of their customers. And particularly if you have employees who are in a high customer contact role or have a lot of interaction with other employees, I think you would be probably grossly negligent as a business if you asked people to return to work and you did not require vaccination. But that being said, there clearly are going to be religious exemptions that may be a bit difficult because I think some of those claims will overlap with politics. But you will also have medical exemptions that the companies are going to have to be sensitive to. Principle 3 is, I think in general, you need to honor your contracts. The principle is important because while exchanges are voluntary, one party often must perform before another party will act. Delivery of a good may precede payment for that good or vice versa. And that's why you have contracts to work out these delivery mechanisms and delivery terms. In either case, a party performs because he or she expects the other party will do so as well in accordance with contract. So it seems to me that honoring contracts is the default ethical stance in a business ethics that's looking to a market economy. The market's only going to be operating efficiently if people, for the most part, voluntarily honor their contracts. Otherwise, we'd be spending a huge amount of money on compliance. Ditto for principal and agency arrangements. Those exist only because the owner can legitimately expect that the managers and their agents are going to adhere to the terms of employment contracts. And clearly there are enormous consequences enormously adverse consequences connected with not adhering to contracts. Diminished trust in the parties in the larger economic system and arrangements, huge litigation costs, delays, uncertainty, and so forth. I'll come back a little bit in the case of the 5th principle of justice to say a bit more about invoking the force majeure clause and the ethics associated with that. But I read that one company has sought to avoid contractual commitment by claiming that there's an implied force majeure clause. There is no force majeure clause in this company's contracts. They don't even have boilerplate apparently, but they're trying to argue now that there's an implicit force majeure clause. I would say from the ethical point of view, that's a problem, that the contracts largely have to mean what they say, and that there's probably an ethical case to be made for more narrow construction of contracts so that people have some kind of predictable interpretations of what behavior, what the contract is going to require and what behavior they can expect. So to go around alleging implicit clauses, I think may not really be in accordance with the principle of honoring your contract. Principle 4 is respecting stakeholder autonomy. This, of course, is a big one, but every organization or business operates with an array of stakeholders understood as parties significantly affected by and affecting the organization's provision of genuinely good goods and services. The stakeholders include managers, employees, customers, and so forth. Both markets and the nature of companies presuppose that people rely upon exchange to enrich their lives in an array of ways. And so to participate in that exchange is to expect that one's trading partners are going to acknowledge that all direct and indirect parties to this exchange are autonomous agents whose autonomy should be respected. That is, each stakeholder is obligated to see other stakeholders as kindred beings with goals, desires, and plans that have a value or worth equal to his or her own goals, desires, and so forth. So this principle of respect typically entails that one should do no avoidable harm to stakeholders and would entail taking some proactive measures to protect stakeholders. So here are just a few examples of Principle 4 that I came up with. Obviously, some kind of provision of personal protective equipment when it can be provided, and to people who are needed. Working from home options provided for vulnerable employees and parents with small children, requiring masks in many contexts. Universities offering online classes, canceling athletic competitions when they can't be done safely, taking conferences online. We've seen many universities do that. We see the airlines not ticketing middle seats as an attempt to respect the autonomy of the customers. Possibly requiring vaccinations, as I already touched upon. Implementing better ventilation. Many of the companies in downtown Chicago have installed better ventilation systems. At DePaul, we've just upgraded our ventilation as a way of making sure that the institution is doing what it can to ensure that people aren't unnecessarily exposed or unavoidably or avoidably exposed to COVID. Clearly posting rules at gyms and then enforcing the rules. Possibly encouraging one's employees to use telemedicine to minimize their risks. I think that firms need to attend to the science of COVID infection and proactively seek to define their own standards and expectations. As Candice was saying, the state responses here are widely variable. So I think organizations need to keep thinking in a proactive way about how to implement these 6 principles that I'm going through. Companies need to avoid price gouging and opportunistic pricing. Here in Chicago, you see that many restaurants now are imposing a 4% COVID charge on restaurant bills, but they're not really accounting for where the money is going. Is it being used for PPE for workers, daycare support for working parents at the firm? I think that that there would be greater respect for the autonomy of customers if, rather than just sticking them with the charge, you actually gave some responsible accounting of where that money was going. We're starting to see a problem at universities where privately some university presidents have apparently said that they're using COVID to jettison employees that they've wanted to get rid of for a long time but couldn't because they were tenured. And I think that that kind of behavior is not going to withstand or pass the ethical smell test. I think firms need to be sensitive to possible effects of economic disparities among stakeholders and among their employees, for example, and maybe even among customers. So for example, here at DePaul, we can't require, and we don't require that students have to turn on cameras. There may be some cases where they just don't have cameras that work, or they may have privacy issues in their home that prevent them or make them ashamed of turning on their camera. So respect for autonomy means being sensitive to these economic disparities. I think it also means that you have to be truthful about COVID's effects at your organization. There have been some stories being talked about now in the Chronicle of Higher Education about student newspapers outing their university administrations for lying about the number of number of students who have had COVID. So you need to be telling the truth about COVID. 2 more quick principles. One, I think you need to act justly. Generally, justice means rendering to each person his or her due and not overreaching by claiming that you alone have all legitimate claims or you alone should bear no risk and everybody else should bear all the risks or potential harms. So examples of overreaching might be refusing to pay rent on your downtown office because you know that the landlord can't easily push back since there aren't a lot of other commercial renters in the offing and civil courts are closed. There may be legitimate reasons why you have to pay less rent, but just as a strategy or a kind of gamesmanship strategy of your first move being just refusing to pay all rent on your commercial properties, that strikes me as a violation of Principle 5. Forcing health and safety risks onto minimum wage workers whom you haven't given maybe necessary security and safety training to. So here was an example I just grabbed yesterday. We've had cases of Walmart greeters who have been assaulted by customers when they've asked people coming to the Walmart to put on masks. And I think that that Walmart can afford to pay for security forces. I don't know that asking greeters to have to take on the responsibility is really a just action. shifting all risk onto one party with waivers, or possibly pushing all burdens onto one party singularly ill-equipped to meet the burden. Here in Illinois, nursing homes are being asked to spend a lot of money on PPE, but their margins are very thin. PPE is expensive, and it isn't clear whether or not they'll stay in business if they have to pay for all this PPE. The city and state here have announced support with great fanfare for the nursing homes, yet very little of that money has been dispersed, according to my research. And so I think that you have then maybe a violation of the principle to act unjustly if you require the nursing homes to bear all this risk bear all this burden of providing PPE for vulnerable people, when it's really in the state's interest and all of our interests to have facilities that can accommodate the elderly. Finally, I think we need to remember that there are always multiple values in play. So that in fact is principle 6, remember that there are always multiple values in play. There are issues here of the value of economic activity, the need for revenue, the need for people to have paychecks, but there's also the psychological value of keeping contracts. There's the value of social connectedness. Having people come into work does maybe help people combat depression. We're seeing in the case of students now, many cases of teen depression and depression among the young, just because they don't seem to have enough social engagement if they're doing all their classes on Zoom. There's the principle of trust in business, with which I began. There's stakeholder autonomy. So it always raises a red flag for me as an ethicist if I hear someone saying in a corporation, there's only one issue here, that we need to make money, or we need to get economic activity going here. Or conversely, if someone would say there's only one issue here, public health, I'd have a problem with that too. I mean, there clearly are a lot of values in play. So I'll stop there. I hope that maybe those principles will provide a little bit of a framework for you to think about issues you have in your own company around COVID. Thank you.
All right, let me unmute myself real quick. Hey guys, so we're going to move into the question and answer. We have a couple of questions that came through the Q&A and the chat. So let me start. I think this is probably geared towards Denis, because that's when it came up. This is from George Pierce. He says, could the parties have a provision in their agreement that a provision remains in effect even if government action waives compliance? For example, if a law is enacted that rent is not due in a commercial lease for 3 months, could a provision in a lease override that? You're muted, Denis. You're still muted, Denis.
Okay, sorry.
Okay.
That happens to me all the time. I think in this situation, the answer is no. The parties cannot agree that to circumvent the public law. The public law will take precedence as a matter of public policy. What comes to mind is, can the parties agree that in no event will a party avail themselves of the bankruptcy code? That will not be enforced. And I think a provision like this would never be enforced if the parties agreed that the law would not apply. Candice, do you have a different view of that?
Yeah, I mean, generally you can exclude, I mean, it's a matter of contract, right? So the contract between the two parties can say or do anything, right? An example of this is, for example, business interruption and exclusions. Insurance, it's a matter of contract, and it clearly says what's accepted and what's not, and that's the end of the game. So, if you have under business interruption that you don't cover if there's a epidemic situation or certain government orders related to that, then you don't cover. Similar, you can mandate contractual performance. So my view is contract is a very flexible land, and what we've been talking about here has been ways to excuse performance in whole or in part. That's a defense to your contractual requirement to perform.
Great, thank you.
Just to clarify, I still go back. I don't think that the parties can overrule a public law.
I don't think they're public laws. So here's my problem with the orders. You get an advisory. For example, Chicago currently has an advisory. So what's an advisory?
No, the question was
executive orders, but what's an executive order? So my feeling is that what if you'd say orders of preemption, if it's state law, and it's you look at Illinois statutes, for example. Sometimes you can contract around them. I'll use an example. LLC, Business Corporations Act. You have default provisions, and then you have the ability to contract around them, right? And that's in your operating agreement. So you have defaults, but you also have the ability to move around them. So I would say in terms of these government orders, I don't know what an advisory is, just speaking legally. I don't know what a governor's executive order is, hence the lawsuits overturning or challenging various executive orders across the states, and sometimes they succeed. So I would be a little hesitant to say absolutely, and that's maybe just the grayness of law, absolutely that you can't contract around government order. You clearly can do it in the insurance context, just as an example. It's in the exclusion, and it includes a government order.
Okay, I thought the question was, if a law is passed, it says no payments of rent, can the parties agree that we're going to pay rent? Is that enforceable? I don't think it is.
I guess I would view that as gray, so I mean, bring it to a court, right? So the landlord would say, we've contracted and this is our private agreement between the two of us. The defense is, I'm excused from performance because I have this state law. Well, okay, state law expires December 31st. Eviction moratorium, for example, expires December 31st. Now what are the duties? And does that apply to what was owed retroactively? So I would say in the rent cases, and I have a commercial eviction case right now in Cook County, I would say right now, what I'm seeing is that all of those rent obligations are fully enforceable, notwithstanding all of these orders, right, that make performance difficult, right, to do. If you have no revenue, should you be paying rent? But can the state, through executive order, or say through a properly passed act of legislation signed by the governor, there aren't many of those in this environment, is that enforceable? And I would say it would be a legal issue. I'm not sure that there's an absolute rule.
Okay, thank you guys. I'm glad we got into a little bit of a debate about this. Another question, where does mitigation of damages fit into this? Is it covered with the partial performance, which only seems to apply to one side, unlike any obligation to mitigate damage?
Well, in the force majeure context, the party that invokes force majeure does have an obligation to act in good faith, to mitigate the harm that is imposed on the counterparty. So that's a kind of a mitigation of damages concept. Alternative, the party that is not affected by the force majeure, do they have an obligation to mitigate damages? Well, first of all, the contract, the party's excused, so there's technically no damages. They can go out and cover their needs elsewhere. Do they have to get the lowest price? No, because they're stuck holding the bag. They have to pay the price they have to pay to get the goods, and the original supplier is off the hook. They have no liability. So the original supplier has a obligation to mitigate, but not the party that's really affected by the force majeure. in my opinion.
Daryl, here's one for you from Tom Carmazzi. Has anyone reviewed the correlation between a favorable culture and employee unrest / lawsuits in the COVID environment? For example, companies in the book, Firms of Endearment, and how they have done in applying these 6 principles?
That's a great question, Tom. As far as I know, this is such a new area. Nobody has done any work specifically on COVID litigation and ethical culture. I mean, I think generally speaking, there has been research that's been done that shows that you have less whistleblowing. You maybe have better communication in companies that have a history of treating people justly and of respecting autonomy and of avoiding coercion. I think in the case of the I don't know, was it wasn't the Tyson or Watts, one of the cases that Candice was talking about where she said it was a communication issue. Oh yeah, I know, your hypothetical case at the very end. I was thinking, yeah, this is a cultural issue at this company, because it seems as though maybe the CEO has not cultivated a kind of culture where people feel free to speak their mind, or where people have opportunities baked into the culture to say, wait a second, what are we doing here? Let's hit the pause button. Can we rethink what we're doing here? If those kinds of opportunities had been there, I don't think you would have had multiple employees going to the state behind the back of the CEO to complain about work conditions. But I did have a question for Candice that did occur to me. My sister works at a university, and the staff, not the faculty, but the staff at this major university have been forced to come back. And actually, there's some data that the staff have that their work productivity was better when they worked from home, because they did student counseling, and the students, they could counsel with more students. The students were more likely to show up for appointments, and the students could also see the screens more easily in the remote Zoom environment than the students could see when they were actually in the office of the staff. So I'm wondering, would the employees have some kind of defense if they could actually show that they're being forced back to work and their work productivity was far higher when they were working in a safer environment? Could they use that to push back against a CEO, do you think, or would that not get any traction in a court of law?
Well, I mean, you can always use facts persuasively and still not get traction. So it's a good fact, right, for the employees. Counterfacts would include preservation of culture, collaboration. There's a lot of counters to that. There's concerns about, say, for example, if there's standardization, right? It's one thing if you could pull people together, but, you lose a little bit of, say, control over how the services are being delivered. So I would say it's a generally helpful fact. Does it have any bearing as to, rights in the employment setting? No. From a legal action, but I throw it into the complaint. And your better option is to couple that fact. It's a good fact. I mean, tell the court that people are happy in doing their business. That's not a problem here, but couple it with negligence. So if you can say that, well, the workplace is unsafe because you can't maintain social distancing, well, that's a problem if you're in a building where everyone has individual offices with doors, as an example, right? And a lot of universities have that kind of environment where people, even in staff roles, don't necessarily need to interact with other folks in a cattle call, right? It's not Tyson Foods. So that's the problem, is that most employers are able to show that they have met a minimum or reasonable standard of care with the COVID guidance that's been delivered so far. So I think it's very hard from an employment standpoint to.
Although I actually think things maybe cut a little bit differently in universities, because it's actually a problem that professors have small offices with the doors shutting, because if the staff have a similar arrangement and they're being asked to bring students into their tight little offices and to shut the door for privacy issues while they discuss the student's performance as they work out the student's advisor plan, then, I think my sister's an advisor would say she's actually putting the student at greater risk in that kind of closed office environment than she was when she was doing a Zoom call with them. So yeah, I hear you.
I have kind of a question that expands on that topic, which is, do you think one could make an ADA argument for reasonable accommodation to work from home? I guess it's an easier argument to make if you have like asthma or some other sort of thing that makes you vulnerable, but could just a normal person make a reasonable accommodation argument?
Yeah, so in order to fall under the ADA, you have to qualify for ADA protection. So, it's not, I'm a healthy 25-year-old and I'm just fearful of COVID, and you have no underlying conditions or special risks or factors. What also seems to be failing is when you say, well, I may be fine, I'm that healthy 25-year-old, but I have vulnerable people in my household and I don't want to expose them. That also seems to fail as an argument. So it's hard. I would say for individuals, if teleworking's available and it's feasible for the business and it's been deployed, and there are individuals who otherwise are protected under the ADA, and you have knowledge as the employer that that's the case, then I would do a reasonable accommodation and be cautious and work with those employees. And think about like what the relative fairness is here, right? Because it's like, oh, yay, I have asthma, I get the special accommodation, right? And then like the poor healthy 25-year-old gets nothing and has to assume all this risk. So it does seem like we have a bit of a haphazard approach and legal construct around how we're treating people, and I'll just say our fellow citizens in the employment situation. It's a little ad hoc. People are experimenting with it, and this is why I said companies like, say, a university or my law firm, we have a lot of flexibility to mitigate those risks. I don't have to make those decisions, right? Because everybody can telework. Right. So that's not a problem for me. It is a problem for UPS, right? It is a problem for Amazon. It is a problem for your local hospital. And that's why you also see the deployment of liability shields as part of a get back to work scheme, which is to try to get employers to feel more comfortable with bringing people back into the work environment.
Thank you. I have one more question because we're right almost at time here. And this is mostly for Daryl, but others can contribute. How do you feel about the ethics of the liability protection laws that are currently under debate? Does that sort of let businesses off the hook ethically, that they don't need to worry about lawsuits and things so they can force their workers to come in? You're on mute.
Right, that's a complicated issue. I guess I think that probably some protection is going to have to be extended to institutions. Even colleges. It's a hot topic now. If you bring your students back to campus, you can put into place all kinds of provisions in the classroom. You can have all kinds of provisions around the library use and so forth. But students are going to get sick, and how does a university prove that the student got sick from the university rather than going from the Lincoln Park bar, going to the Lincoln Park bar down the street, 6 times during the first month that he was in college. So I think that a liability shield might be necessary just to build the level of confidence. The problem is the moral hazard problem, that you may encourage all kinds of bad actors then to take inappropriate risks or to not act proactively, and that's where the 6 principles I tried to sketch would come into play, that firms still do have an obligation to not coerce, to act justly, to respect autonomy and so forth.
Great.
Yeah.
Thank you.
Complicated.
Yeah. Well, thank you guys. I think we're at time here, so I want to respect everyone's time. I will, just as a reminder, I'll be sending kind of a follow-up email to everybody with sort of a quick survey of how you felt about today's event. I'll give you the certificate of attendance for your CLE and CPE purposes, and I'll attach the slides and contact info for the guests today, so you can have any, if you have any follow-up questions for them, you can reach out. But thank you to our 3 panelists, and thanks to our audience. Hope everyone has a great evening.
Thank you.
Great, thank you.